So, good morning, everyone. Welcome to June's payroll update. I'm Helen Hargreaves, Head of Payroll Policy here at MBKB. I must tell you that I'm recording this session because it's going to be available on the MBKB website. So please bear that in mind if you have a question. For the agenda today, we are going to start off with a COVID-19 update, and then we will look at some things that have come out of HMRC over the last month or so. There are a couple of things going on with statutory payments, so I'll talk through that, and then we'll have a look at employment rights, followed by a payroll update. If you can use the chat box to ask any questions that you might have, and then I'll pick those questions up at the end. It's a bit more streamlined doing it that way than trying to pick up the questions in the chat box as we're going along, because the time taken to type a question usually means that we've moved on to the next topic by the time the question comes through, and it ends up being a bit backwards and forwardsy. So if you leave all the questions until the end, and then we can do it a bit more smoothly. So let's start with the COVID-19 update. So although the government has delayed the lifting of all lockdown restrictions until the 19th of July rather than 21st of June as they previously planned, the Chancellor, at the moment at least, doesn't intend to extend the furlough scheme beyond September, which is causing a little bit of controversy in some areas. But that means that because we've not got an extension, the planned tapering of the CJRS scheme is still going ahead. So the amount that employers who are still furloughing staff can claim from the scheme is going to begin to taper off from the 1st of July. So if we look at the funding timeline on the screen, in June, we're still along the same lines as the previous month. So employers can claim back 8% of the wages, capped at £2,500, but they do still need to pay the employer national insurance and pension contributions. But from July, that's when that taper starts to kick in. And so employers can claim back 70% of the wages, capped at £2,187.50, but the employee must still get 80% of the wages. So the employer has to make up that remaining 10%, plus still the employer national insurance and pension contributions. And then for August and September, that government contribution reduces to 60%. So employers can claim back 60% of the wages, and they must still make sure that the employee gets 80% of the wages. So the employer has to top up that 20%, as well as pay the employer national insurance and the pension contributions. It seems a little bit ironic as the coronavirus job retention scheme, the CJRS, starts the tapering down period from the 1st of July. It seems a little bit late in the day for HMRC to start making it easier to claim a CJS grant, but if you've got between 16 and 99 employees that you've been claiming for, I feel your pain if you have been manually uploading all the details for each individual employee. So I'm not going to criticise anything that reduces that administrative burden for payroll. So up until the 27th of May, employers could use a template to upload employee details if they had more than 100 employees. But if you had less than that, then that's when all the manual work came in. So HMRC has now produced a template that means that employers no longer need to manually update that information if you want to claim between 16 and 99 employees. The template is also supposed to make it easier for employers to make sure that they've included all that relevant information when submitting the claim, because you have to make sure that you put all the information in the right format so that your claim can be processed quickly and successfully. But if you don't, then it will get rejected and flash up and tell you what's wrong so that you can correct it. So there are two different templates. So it's not just one template for 16 employees and more. So there's a template for between 16.99 and the existing template for 100 or more employees. If you want to submit now using that template for between 16 and 99 employees, you have to submit a file that contains the following information for each employee. So you must give the name, the national insurance number, or the pay reference number if you don't have a national insurance number for them, the furlough start and end date, the full amount that you're claiming in pounds and pence, the normal hours, the actual hours worked, furloughed hours, and whether the employee has returned from statutory leave and then been placed on furlough, because that affects the way that you do the calculation. As I've said, the template could be rejected if the information isn't provided in the correct format, but if you do make a mistake, the file won't be accepted. The mistake will be highlighted so that you can put that right and then submit the claim again. What is really important is that you don't change the format of the file because otherwise it won't be accepted by the system. So when you use this template, you must make sure that only the information that I've just said is included on that you use one line per employee for the whole period. The calculation isn't broken up into multiple periods. That you don't split data by contract type. So those paid on a weekly and monthly basis should be claimed together. The correct amount of columns are provided, so not less, not more, exactly as that format's laid out. At the start of the pandemic, thousands of employees were forced to work from home. Hundreds of thousands, to be fair, and something that the vast majority were not initially equipped to do. So as well as employers rushing to purchase IT equipment such as laptops and mobile phones, they also supplied or reimbursed equipment such as office chairs and desks so that a worker could set themselves up with the right equipment that they needed to work from home for a prolonged period. And because of this, and in light of the pandemic and the government advice that everybody's told to work from home, HMRC made a temporary exemption to employer-provided equipment and reimbursed equipment regulations, which meant that there was no benefit charge arising if equipment was provided or the cost of equipment was reimbursed, if it was purchased solely due to having to work from home because of the pandemic. So normally employer provided equipment would be a taxable benefit, but because of COVID, this exemption was brought in, and as long as equipment was provided under those conditions, then there wouldn't be a taxable benefit charged, and that exemption lasts until April 2022. But remember, a benefit charge will arise if the office equipment purchased by the employer is not returned by the employee. So if the employer says, no need to bother bringing it back when you come back to work, keep it, then that's when a taxable benefit charge will occur, because ownership is then transferred from the employer to the employee. It would seem that there are quite a lot of employers that haven't taken that into account, and they've said to employees that you don't need to return the equipment, don't worry about it. I guess employers are worried that they're going to have a room full of spare office chairs or desks or whatever. So this month's employer bulletin has highlighted this, that some employers are forgetting about the fact that if they tell the employee, don't worry, you can keep it, then they will have to be put down as a taxable benefit. But if an employee who purchased the equipment themselves and then the employer reimburse back the exact cost of that equipment, then there isn't a taxable benefit charge, because there isn't a transfer of ownership. So that exemption that runs through until April 2022 still allows purchases to be non-taxable if they were purchased due to having to work from home due to the pandemic. So in summary, if your employee purchased their own home office equipment for use while working at home as a result of coronavirus, and the employer reimburses the exact expense, unless the employer has said specifically that the employee must give the chair or the desk or whatever it is back when they come back to the office, then there is no taxable benefit because ownership rests with the employee. There's also no benefit charge if the employee is allowed to keep equipment as long as it's something that they already own. So make sure that if you've got people who are working from, if you indeed yourself are working from home, make sure that you are fully aware of what the taxable benefit exemption rules are, and don't accidentally fall into one because you give the equipment back to the employer later. So some HMRC news now. Since the start of the pandemic, people have been having all sorts of problems trying to obtain a national insurance number. I don't mean find out what the national insurance number is because you've got one and you can't remember it. I mean people who genuinely don't have a national insurance number that have to apply for one. So because of the problems of COVID-19, DWP has been limiting the number of national insurance numbers, or NINOs, that it issues, because and this presented employers with some difficulties if they were trying to take on a new employee who didn't have a NINO. The problem was that before it can issue a NINO, the DWP must confirm the applicant's identity and the right to work in the UK. And these are usually done by face-to-face interviews. If prior to coming to the UK, the individual has already been granted permission to work in the UK by the Home Office, then the DWP has been able to validate that application with the Home Office, and they can issue the NINO without the need for that face-to-face interview. But the face-to-face interviews are the thing that's had to stop because of COVID-19. Because DWP has to examine the original identity documents during a face-to-face interview, that has been the stumbling block to being able to switch it online and offer a digital service. We were told last year that DWP was developing a digital solution and it would be available during the autumn. Autumn came and went, and the digital service did not arrive, but the digital service has now arrived. So as well as the digital service, the DWP have also restarted the face-to-face interview services. So the problem that we've got is that there is a huge backlog. There's more than 12 months worth of applicants who need a face-to-face interview who are in the queue. So DWP have said that people should use the digital online service initially, and you can prove your identity using the passports from any country, or a biometric residence permit, or a national identity card from certain countries. Now, in the main, those certain countries are the EEA countries, so that's all those in the EU, plus Norway and Liechtenstein. Now, it does include Switzerland, that isn't part of the EEA, and doesn't include Iceland, which is part of the EEA. But other than those two, Switzerland and Iceland switching places, essentially it's everyone in the EEA. ID cards are allowed. Always try to make an application online initially, and then if the DWP does need to hold a face-to-face interview, the applicant will be advised that way. The advisory fuel rates go up or are reviewed every 3 months. You can see from the chart on the screen that virtually every rate has gone up this time, and that's because of the increase in fuel prices. So employers have a choice. They can either start to implement these rates for 1 month from the date of change. You can either use the previous or the new current rates if you want to. So this is something that people have been asking for years. So up until now, there hasn't been an option to pay as you earn or NIC through the bank account, as either, as we would say, direct debit or just through your online banking. You could pay by a debit or credit card, but you couldn't pay through the bank. And the latest edition of Employer Bulletin says that now this new service is available, and what you need to do is log into your HMRC online account, and then that's got some technology called open banking, and that will store your HMRC reference information, but then it will take you out to your bank so that you can make payment. Your payment details and your payment reference details are together in that same transaction, so you know that your money is going to go to the right place, but it's also protected within that HMRC technology. And then go through to your bank, tell it how much you want to pay, and then it will bring you back to your HMRC online account again. Initially, you have to go through your online account, but moving forward, HMRC's wish is that the service will be extended to people who don't have an online account as well, but we will wait to see how that one pans out. So, statutory payments. We will start first of all with calculating statutory payments when the off-payroll working rules apply. There's been a lot of advice and guidance published since the expansion of off-payroll working into the private sector this April. Impacted employers should be able to find the help that they need. But as the guidance makes clear, workers providing the services through an intermediary are added to the payroll purely for the purposes of collecting pay as you earn and national insurance. So there's no pension contributions, there's no student loan deductions. They're not employees with the associated employment rights. So what happens if the worker is sick or takes a child-related absence? Well, the answer is that the intermediary is the worker's employer. So the intermediary is responsible for making those statutory payments. And so HMRC has published some new guidance that explains how intermediaries can calculate statutory payments for the workers where the off-payroll working rules apply. So I've included this slide in here because it might be that you do provide a payroll service for an intermediary anyway, or it might be that you work for an employer who has contractors providing services through an intermediary, and they ask you the question, well, what happens about sick pay or maternity or whatever it might be? And so I've included this slide so that you know what that answer is and that you are able to provide that guidance. So if we look at gross earnings, first of all, a worker's entitlement to statutory payments is calculated by using all the gross earnings that are subject to Class 1 national insurance from a relevant period. But when off-payroll working income is paid to a worker's intermediary, it's already net of that tax and Class 1 national insurance. So a worker might receive some earnings that have been subject to deductions under the off-payroll working rules and some that aren't. So they might be providing some services to one company and the off-payroll working rules apply, so tax and national insurance has already been taken off. It might be that they provide services to another company within that same period and they get all that payment because the off-payroll working rules don't apply. So the intermediary has to try and work out what the gross pay is across that relevant period to be able to work out the statutory payments. Looking now at the earnings period, because that can create a bit of confusion. When the deemed employer, so the person that is receiving the services, when they make a deemed payment to the worker's intermediary, so essentially they are paying the invoice, but they've already taken the tax and national insurance off, that is not the earnings period for statutory payments. Nor is it the point where the worker's intermediary receives the payment, because what's important for statutory payment purposes is their employment with their own intermediary. So it's when they get payment from their employer, not when payment is passed from one business to another. And it's that period that determines what the statutory payments period is and what income has been received within that period. HMRC's guidance gives 3 different ways that the gross amount of off-payroll working income can be taken into consideration. And the reason it's had to give 3 different ways is because payroll software, different softwares work different ways. So HMRC has given 3 options depending on how your payroll software works. And there are 3 different options. There's one which is total gross pay subject to class 1 NICs for the relevant period, that can be overridden in the software, that the final statutory payment amount to be paid can be overwritten in the software, or that there's an additional box in payroll software where gross off-payroll working income can be added to non-off-payroll working income for that relevant earnings period. So essentially, this is just for background knowledge, either that you're running the payroll for an intermediary anyway, or that your company has taken on a contractor and the off-payroll working rules apply, and so that you just need to know what that principle is in case you get any questions about it later on down the line. And hot off the press, yesterday, the Department for Business, Energy and Industrial Strategy, or BEIS, unveiled a new online tool so that it will help parents to work out whether they are eligible or entitled to shared parental leave and pay, and if so, how much pay would they get? Shared parental leave and pay means that after the birth of a baby or within a year of placement of a child who's been adopted, parents can opt to enter into a period of shared parental leave, so they can take up to 50 weeks of leave and share it between them and share up to 37 weeks of pay. They can agree a pattern of leave. I know when I used to talk about shared parental leave before, when it first came in, I used to say to people, whatever rules you think are in place for statutory leave, rip them up for shared parental leave, because if someone asks for something to happen, the chances are the rules will allow it. So you really, really have to close your mind to what else you know and focus specifically on the rules for shared parental leave, because they are so different. So parents are able to agree a pattern of leave that works for them and their employer, and they can spend up to 6 months off together. They can alternately stagger the leave and pay, so that between them, one parent takes 6 months, the other one takes 6 months, but they might do it in a block of 2 months each. and switch between themselves. They can take leave and pay up to break it up into at least 3 blocks. So they are allowed to take 3 blocks of leave by law, but if an employer agrees, they can take more. They can return to work in between blocks of leave. It doesn't cancel it out. They can work for 2 months. They can be on shared parental leave for 2 months, in off. That's absolutely fine. Parents also have access to up to 20 days shared parental leave in touch days or split days. Those are in addition to any kit days that the mother takes under maternity leave. And essentially, using the split days and the shared parental leave can help parents to trial part-time working. So they could use it, shared parental leave plus split days, to trial whether a 2 or a 3 or a 4-day working week might work moving forward. But because of all this, shared parental leave and pay is really, really complicated, and it's not just employees that can't get their head around it. A lot of the time, the employer, HR, payroll, they struggle as well. So that's why this calculator is being introduced. So I've included the link on the slides, and if you do get anyone approaching you about it, then at least you know where you can go and see what the entitlement would be. Moving neatly on from statutory payments, we'll move on to employment rights. It's been a long time in the making, but the government has at last announced the launch of a workers' watchdog that takes responsibility for tackling modern slavery, enforcing the minimum wage, and protecting agency workers. The new enforcement body is going to gain new powers, giving it the ability to ensure that vulnerable workers get holiday pay and statutory sick pay that they're entitled to as well. Because at the minute, other than HMRC enforcing national minimum wage, there is no enforcement body that workers can turn to if they think that they're not getting the rights that they are entitled to. Their only course of action at the minute is going through an employment tribunal, which would be scary for anybody. So this new body is going to be the one-stop shop, so that employees who feel that they're not getting that fair treatment that they are entitled to, they can go to this enforcement body and get the help. And it will also, the body will also produce guidance on best practice to help employers understand the rules. There are 3 bodies who look after other employment rights areas. So you've got, as I've already said, HMRC monitors the national minimum wage. You've got the Gangmasters and Labour Abuse Authority, and you've got the Employment Agency Standards Inspectorate. So one looks after agency workers, one looks after those who work in like agriculture and that kind of thing in the Gangmasters, and then you've got national minimum wage. But for the rest of us, there is no enforcement body, but there will be. The problem is that to enforce this, it has to go through Parliament, and we have to get primary legislation. So they're looking to see when we are going to get some parliamentary time to be able to put this legislation in motion. So that's why we've not got an implementation date yet, because parliamentary time's all over the place with everything that's going on at the minute. Fire and rehire. Many employers have changed their employees' terms and conditions during the pandemic, whether it's simply to change the contract to access the furlough scheme, or whether they're wanting to change the terms and conditions in a contract to try and ensure the survival of a business through the troubled economy. Some employees have been willing to agree to the changes because they're keen to avoid redundancy, others less so. Now, obviously, most payroll practitioners don't work in HR, some do, but most don't. But payroll very often gets involved when contracts change, when pay rates change or other terms and conditions change. We do get involved, obviously, when it changes for a good way, if someone's promoted or something like that. But there's the new phenomenon that is becoming increasingly common, and that's fire and rehire. So if due to the economic times, an employer wants to change the working conditions, usually that they're paid less, they will put it to the workers. Where employees don't agree, an employer will give lawful notice to end that contract and offer a new contract under the new terms. So that is the firing and the rehiring. They're bringing one contract to an end and they're giving them a fresh contract. Provided the employer's got a sound business reason for making the change, the dismissal is likely to be fair, provided the employer's gone through a fair procedure, including detailed consultation before dismissing. Now, I've included this topic here because I suspect that as furlough draws to an end and we really start to see the impact of COVID on businesses and the economy, you might well come across this situation and you might wonder whether it's legal. Let's say it now. I'm not a lawyer, so do not take this as any kind of legal advice in any shape or form. But based on what's happened so far, I can give you a bit of background into how a couple of cases that have already gone through this have panned out. So fire and rehire was brought into the spotlight really recently by British Gas. British Gas had been in a long-running dispute with boiler engineers over changes to the terms and conditions of employment. The 9-month dispute resulted in numerous strikes backed by the trade union. The engineers were asked to sign new contracts which required them to work longer hours for no extra pay. Originally, around 1,000 engineers refused to agree to the changes to the contracts, and as a result, British Gas deployed the fire and rehire strategy. So they ended their contracts and offered them new ones. And the engineers were forced to choose between accepting the new contractual terms or being fired. Many of the 1,000 didn't like it, but did sign it anyway. But we still had round about 500 employees who decided not to accept the new employment contracts and as a result were dismissed. So there is still those who wonder, is that the end of the matter, or is it going to become a subject of a big employment tribunal court case? As a note for employers, if they're going to do this, if they want to amend contracts, then they have to consult with the employees. They have to get consent. But where that consent can't be reached, then the employer has two options. They can either impose the contractual changes without the employee's consent, which is called make unilateral changes, or they can dismiss the employees and offer rehirement on new contractual terms, which is the fire and rehire. But the process of fire and rehire exposes the employer to claims for unfair dismissal. The employer might successfully defend the claims if it can establish that the reason for dismissal was for some other substantial reason. So it's a general catch-all business reason, and that it acted reasonably in dismissing the employee for failing to agree to the new contractual terms. But what are the chances of the British Gas engineers claiming unfair dismissal? Any employees who want to bring claims against British Gas will need to engage with ACAS conciliation before they start unfair dismissal proceedings. So it might be a while before we learn of any actual claims. But there has been a recent case, which is Khatun versus Wynn Solicitors. And there, the dismissal of a solicitor for refusing to accept new terms during furlough was held to be unfair. So that one is worth watching closely. So any employers who do want to encourage employees to accept contractual changes, first of all, make sure that the workers understand why you're doing that, whether the changes are coming in for a limited period or whether it's permanent contractual change. If employees understand that the changes are being made to save costs in order to avoid compulsory redundancies, then they're more likely to accept the changes. And employees should be allowed to express their views. So employers should be empathetic towards those views, to understand the concerns. Sometimes all it needs is for employees to know that their voices are heard, even if you can't do what they want. But it's going to be very interesting to see how this pans out and whether there are going to be more coming in the future. And if you get any in your business as well, then make sure that you are aware of what's going on and understand those legal ramifications. PayrockPayroll is having a virtual networking event on the 9th of July. You are very cordially invited to join us. So it's 9th of July between 1 and 2:30. And in this first event, what we have got are 3 aims to get out of it. So we want you to be able to meet members of the PayrockPayroll team, to find out more about PayrockPayroll membership and training courses. But at the heart of it is going to be a discussion. It's not a training event, it's a discussion. And we want to focus on national minimum wage for this first event, because national minimum wage is something that has all sorts of complexities to it. But the rise of home working could well bring some additional complexity. I don't think it will be long before we start to see court cases where people say that they're not being paid the national minimum wage because they were still working and answering emails at 10 o'clock at night or on a Sunday morning or whatever. Because as a home worker myself, I know that the strict, rigid office hours tend not to get stuck to when you're working from home. And I think it's going to become more and more difficult for employers to monitor the hours of workers when they're working at home. So we're going to have a discussion just for people to exchange good practice, to discuss concerns, and see if anybody's got any bright ideas that the rest of us can take on. So that should be a really good event, 9th of July between 1 and 2:30. If you want to book your place, the link is there. So has anyone got any questions? I've not got any coming through yet. I know sometimes it can take a while for fingers to fly over keys, so I'll just give it another minute or so. And if nothing appears in the chat box, then we will wrap up this session. So nothing has appeared. So I would just like to thank you all for your time this morning. I hope you found it informative. The webinar will be available on the MBKB website if you need to have another listen later on. And in the meantime, I wish you all a very, very good rest of the day. Take care. Speak to you soon.